Okay, class. Today we are going to continue our discussion in evidence. And this time we are going to discuss two important concepts in evidence. Important concepts in evidence. The concept of factum probandum and factum probans. In evidence, uh, uh, there is an interplay between two facts. Okay, namely factum probandum and factum probans. Now, later in our discussion, we'll be defining what factum probandum is and what factum probans is, give examples of each, and how they relate from each other. Okay, so for the definition, no, factum probandum is the ultimate fact or facts sought to be established. Also, we define factum probandum as the fact or proposition to be established. Okay, factum probandum is the fact to be proved, no, in a certain case. Okay, it is a fact which is in issue in a case and to which the evidence is directed. Okay, so in a certain case, in a particular case, this factum probandum is the ultimate fact that must be established. So all our evidence, okay, all material evidentiary facts must be directed to this factum probandum in order to establish this proposition. Okay, this proposition. Now, what is factum probans? So, factum probans is the evidentiary fact or facts by which factum probandum is to be established. So, simply put, these factum probans, these are the facts which prove factum probandum, or the facts or material evidencing the fact or proposition to be established. And this fact or proposition to be established, we call this as the factum probandum. So, factum probans proves factum probandum. Okay? Factum probans is the probative or evidentiary fact tending to prove the fact in issue. Okay, and this fact in issue, as I repeat, is the factum probandum. Now, examples. Now, let's proceed with the examples. No? We proceed with the examples. Now, we defined a while ago that factum probandum is the ultimate fact to be proven. Let's give a particular case. In a case for murder, the factum probandum would be that the murder was committed through treachery. So here, the ultimate fact to be proven is that the murder was committed through treachery. So that is the factum probandum. Okay. Now, in order for us to give a definite factum probans in this particular proposition of law or particular factum probandum, we have to define what treachery is. Okay, and as per a legal definition of treachery, okay, there is treachery or alevosía when the offender commits any of the crimes against persons, employing means, method, or to ensure its execution without risk to himself arising from the defense which the offended party might make. So that is treachery. Now, or kumbaga, when we say treacherous yung pagkakapatay sa kanya, we mean that walang opportunity yung victim to defend himself. the attack was, for example, sudden or unexpected, it was very swift, giving no opportunity for the victim to defend himself. Okay, so in this particular factum probandum that the murder was committed through treachery, no, we give as evidentiary fact or factum probans, for example, that the exit wounds were in front, indicating that victim was shot at the back. So this is the evidentiary fact which proves the ultimate fact. Okay, or in short, this is the factum probans that proves the factum probandum. Okay, another example in a case for robbery, no, we give as factum probandum that the robbery was made through force upon things. So what are the facts evidencing that uh, the robbery was made through force upon things? Okay, or in short, what are uh, the factum what is the factum probans in this particular factum probandum? Okay, and in this particular case, no, for robbery through force upon things, no, the factum probans would be that the locks, no, the locks were destroyed, which indicate, no, that there is force upon things. Okay, the destroyed locks indicative of force upon things, or uh, the broken was damaged, no. So those are the factum probans establishing the factum probandum that the robbery was made through force upon things. Okay, so if factum probandum signifies the fact or proposition to be established, then matters of judicial notice, conclusive presumptions, and judicial admissions cannot qualify as parts of the factum probandum of a particular case because such matters need not be established or proven. So in this case, no, matters of judicial notice, conclusive presumptions, and judicial admissions, these matters need not be proven. That's why it's not part, no? They cannot qualify as parts of a factum probandum. Okay, that's all for now. I hope you have learned something and please watch the other videos. Okay.